You good? Members, I now detect a quorum. Yep, that's right. So we're going to call Civil Justice Full and Committee into session. All right. Members, do we have any personal orders? Oh, I'm sorry. Clerk, call the roll.
Representatives Bricken, Clemens, Curcio, Eldridge, Farmer, Garrett, Gillespie, Harris, Littleton, Ogles, Parkinson, Ramsey, Smith, Stewart, Vice Chairman Jernigan, Chairman
Here.
Carter. Mr. Vice Chairman, you have a quorum.
Thank you so much. Now, does any members have any personal orders? Seeing none, we're going to jump right into the calendar that we have today. I am going to take item number 3, House Bill 159, out of order. Chairman Williams has pressing matters in other places. So we have a motion and a second. The bill's properly before us. Chairman, you're recognized.
Yes, Chairman and members, I have an amendment also that I would, that amendment drafting code 005905. This rolls two amendments together. It goes back, the subcommittee wanted to make sure that we were clarified about higher education foundations. This would preserve them and allow, for instance, Tennessee Tech or Austin P or any of the other institutions of higher learning to be able to communicate with their foundations. It allows them to do that. And it also, one of the other concerns of the subcommittee was questions about PACs. And I just want to make sure I clarify, this bill does not change anything in regards to PACs and what they have to disclose. This bill does not change anything in regards to what is currently having to be disclosed to any agency. We're just making sure that the information stays confidential and doesn't get released to the public. With that, Chairman and members, I'm happy to answer any questions you might have.
Representative Stewart.
Did you bring a similar bill last session?
I did, yes.
Okay.
And the Senate, we did pass it in the House. The Senate didn't take it up.
Okay. And what is the problem we're solving? Like, why do we want to make people's involvement with these entities confidential?
Well,
Sure.
thank you. Well, in some instances, private donors want their names to be anonymous. For instance, I sit on the State Habitat for Humanity Board. That board received a large financial contribution from an individual who wanted to be anonymous. Technically, if under current statute, you could get that information as to who it was from. This would just preserve the right for those things to be private.
But wouldn't it also, pardon me, Mr. Chairman, thank you. Wouldn't it also essentially allow large donors to use charities to take actions that may relate in different ways to governmental activities?
No.
That we need to know about?
No, it would not.
I mean, isn't this a way that somebody, say I'm a billionaire, I'm in Colorado, I want to significantly influence policy in Tennessee, I set up a 501c3, act through that 501c3, now my money is essentially anonymous. Why doesn't it work that way?
The contributions would be preserved. The name, and it would mirror exactly the way the federal government requires it now. So it would be preserved in the same way.
Chairman Stewart.
I guess my concern is I think you're potentially creating a kind of dark money situation where we can have people from outside the state influencing our state affairs. I think they should be public, which they are now. And I worry about putting a shroud of confidentiality over that. But thank you for answering my questions.
Chairman.
The information is still preserved at the Secretary of State. It just would be, you would have to get the information from them. Thank you.
And Chairman, this is all 50Cs, right? 501.
501Cs. All
Cs, just
no, I'm
all.
It's all 501Cs.
All 501Cs. Okay. Members, any further questions? This is your last follow-up question, Chairman Stewart.
You're very strict, Chairman, but I know you're doing a good job. No, it was actually a follow-up to the question that you asked, Chairman, which is, I didn't understand, so this would apply to a 501c4 political entity too, is that fair?
This bill would apply to any 501c.
Thank
As to
you.
whether a 4 is a political entity, I don't know.
Thank you.
Okay. We need to put the amendment on the bill. Question been called on the amendment. We're going to put Amendment 5905 onto the bill. All those in favor say aye. Those opposed? Ayes have it. We're now on the bill as amended. Question's been called. The amendment makes the bill, right?
Yes, sir.
Yeah. So question's been called on the bill. Without objection, we'll be voting on House Bill 159. All those in favor say aye. Those opposed?
No.
No. Ayes have it.
Thank you, Chairman, members, for taking me out of order.
Corbin's a no. Oh, sorry. The bill goes to Gov Ops. I usually say that on the front end. Okay. Now we're going to go back to item number 1, House Bill 167.
Thank you.
By Chairman Moody. We have a motion and a second. It's probably before us.
Have you read the book, Dark Money?
Chairman, you have an amendment, 5560, is that correct?
Hang on.
Okay,
I'm so sorry. You were so sweet to get right to me.
that's all right.
55560?
5560, that's
Yes, sir.
correct.
Yes,
Okay.
sir.
And
We put that on in sub, and what we have here, can I start this way?
You want to start with the amendment?
Yes, yes. This came through a meeting of some that were for the bill and some that I realized later that had a little heartburn. So we all got together and agreed upon this amendment. And so what this does, it defines a crisis intervention, which means a session at which a crisis response services are rendered by a critical incident stress management team member or leader prior to, during, or after a crisis or disaster. And the crisis response services means consultation, risk assessment, prevention interventions, referral, and crisis intervention services provided by a critical incident stress management team to individuals affected by crisis or disaster. And in particular, we're talking about law enforcement.
Okay, and the amendment makes the bill?
Yes.
Okay. Members, you heard the explanation. Are there any questions for the chairman? Seeing none, the question's been called on the amendment. Without objection, we'll be voting on putting the amendment 5560 on the bill. All those in favor say aye. Those opposed, ayes have it. We're now on the bill as amended. And question's been called on the bill. Without objection, we'll be voting on House Bill 167 to go to calendar and rules. All those in favor say aye. Those opposed, ayes have it.
Thank you, Mr. Chairman and
Giddy up.
committee.
All right.
Thank you for being patient with me getting here. Thank you.
Yes, ma'am. Item number 2, House Bill 1594 by Representative Towns. I don't see him. We'll be rolling that to the Hill. We did item number 3. Item number 4, House Bill 928, Representative Campbell. Representative, you also have an amendment, 5527, is that correct?
Yes, sir, that is correct. 5527.
Got a motion and a second on the amendment. And does the amendment make the bill?
Yes, sir.
Then let's put the amendment on. Got a question on the amendment. Without objection, we'll be voting on putting amendment 5527 on the bill. All those in favor say aye. Those opposed, ayes have it. We're now on the bill as amended, if you'd like to explain it.
Thank you, Mr. Chairman and members. This affirms that any treaty, executive order, rule, or regulation of the United States government that violates the Second Amendment of the United States Constitution, as determined by the United States or Tennessee Supreme Court as null, void, and unenforceable, and prohibits the state and political subdivisions from using public resources to enforce, administer, or cooperate with the enforcement or administration of any such treaty, executive order, rule, or regulation. And this amendment did deviate obviously, it rewrote the bill, so the original intention was to be very clear in the Tennessee Code exactly Tennessee's position on the Second Amendment in the event that anyone needed to know that, whether that be a court or anywhere else in the state or country. And we find ourselves potentially in situations where we could end up, I believe, with some unconstitutional measures trying to be forced upon the state of Tennessee and our citizens. Thank you.
All right, well, I'm gonna kick us off here. So, but if the U.S. Supreme Court rules, then that's the supremacy clause, and we follow the Supreme Court, correct?
And, Mr. Chairman, I would agree with that. My concern is we see situations where courts make decisions, and if we don't put clearly what we want to happen in Tennessee Code, we may end up in a much different situation, and I think that's been evident in a separate issue within the past year or so. Yes, sir.
So, okay, so we're still following the Supreme Court's ruling, though,
We
correct?
would be if that were to
Okay,
occur.
so we're
and
just
I
kind of
had-
wearing pants and suspenders here at the same. We're
The-
just double making sure that that's what it is, correct?
Well, Mr. Chairman, I think that it is a good thing to wear those suspenders if necessary,
Okay.
being what that may prevent. And the Tennessee Department of Safety,
right.
and that did occur to me, by the way, recently. I don't want to talk about it, but just the other day, the Tennessee Department of Safety is part of the reason that we have amended this bill to include the Supreme Court language.
Okay, good deal. Members, for explanation, I'm sorry, Chairman Curcio's first on this. I got you down.
Thank you, Mr. Chairman. I was going to move previous question, but I think I'm happy to pass.
Thank you very much, Representative Parks.
Thank you, Mr. Chair. And I'm trying to understand what we're doing here. So, just a couple of questions. So, if the United States Supreme Court made a ruling on, and this is a resolution, am I correct? Is it a resolution?
No, it's a bill.
It's a bill. Okay. If the United States Supreme Court made a ruling under your bill, we wouldn't abide by that ruling if we didn't agree with it.
Go ahead, Representative.
If the Supreme Court were to, at the state or federal level, I should say, if the Tennessee Supreme Court or U.S. Supreme Court deem an action of the federal government to be unconstitutional, this would outline the process of what would then occur in the state. So in other words, we would be doing what the court tells us to do, with an item being deemed unconstitutional. And I just think it's imperative that we put in the code exactly what we intend to happen, because frankly, we don't always get what we want when the judiciary makes a decision.
Thank you,
Yes, sir. Go ahead.
Thank you, and thank you, Chairman Curcio, for allowing me to get a couple of questions in. So, so if we deem what the Supreme Court of the United States says is unconstitutional, I guess if the Tennessee Supreme Court disagrees with the United States Supreme Court, then this would outline the process, the things that we would do in regards to not complying with the ruling that came from the Supreme Court. Am I correct?
Go ahead, Representative.
Thank you, Mr. Chairman. If, as the bill is now written with the amendment being adopted, if either the U.S. or Tennessee Supreme Court were to determine that an item violates the Second Amendment, then we would adhere to that court's decision, of course. And this specifies what would happen in those circumstances. I'm just afraid there may be some individuals that may be in a jurisdiction somewhere, they don't agree with the court's decision and try to go into business for themselves. And certainly wouldn't want that to occur.
Right. And last thing, you had mentioned Department of Homeland Security. Well, what happened with Department of Homeland Security? And are they asking you to bring this bill?
Representative.
Thank you, Mr. Chairman. I mentioned the Department of Safety.
I'm sorry.
They did not ask for this bill. This is not their bill. They requested that there be amendment language that clarifies who makes the decision as to whether the item is unconstitutional or not. So that's what we would do accomplish by virtue of their requested language.
Okay. And last question, Mr. Chair. Thank you for your indulgence, committee, and Mr. Chair. Is the Department of Safety, are they supporting the bill? Are they in favor of the bill?
Representative.
Thank you. I am not sure if Ms. Stroker is in this room or not. I can tell you that she spoke in the subcommittee, and Chairman Curcio, correct me if I'm wrong, my understanding was that the amendment that we have adopted addressed their concerns.
Okay, thank you, Mr. Chair. Thank you, committee.
Okay, we have a question called, so without objection, we'll be voting on House Bill 928 as amended to go to calendar and rules. All those in favor say aye. Aye. Those opposed? Ayes have it. We're going to move on
Thank you.
to the calendar and rules. Item number 6, House Bill 1362, or I'm sorry, 5. Item number 5, House Bill 447 by Representative Warner. There he is. We have a motion and a second. Representative, you're recognized.
Thank you, Mr. Chairman, members. House Bill 447 makes changes to the child support advocacy group. What this bill does is adds voices for those receiving and paying child support and strengthens accountability amongst the transparency for the group. It adds 2 members, sir.
Members, you heard the explanation. Question's been called. Without objection, we'll be voting on House Bill 447 to go to calendar and rules. All those in favor say aye. Aye. Those opposed? Ayes have it.
Thank you, Mr. Chairman.
All
Thank you,
right.
members.
Yes, sir. Now, number 6. House Bill 1362 by Representative, Chairman Carter. I think, Garrett, you're going to run this bill?
Yes, Mr. Chairman.
Okay. We have a first and a second before us. There's an amendment on the bill, 5775, I believe.
That's right, Mr. Chairman.
Got a first and second amendment. Does the amendment make the bill?
Yes, it does.
All right, we're going to put this on so we can, we're going to vote on Amendment 5775. All those in favor say aye.
Aye.
Those opposed, ayes have it. We're on the bill as amended. And Representative Garrett?
Thank you, Mr. Chairman. I'm carrying this legislation for Judge Carter. It's an honor to carry this legislation for him. And this also was brought to him from the Court Clerks Association and also with the help of the Tennessee Bar Association. What it is, it's an outline to strengthen the small estate probate matters. These are matters that are probated for $50,000 or less when there is also no real property. So usually it's just personal property, maybe there's cash in the bank and there's no way to get to that particular asset without going to probate, and it's a cheaper process to go under the small estate procedure rather than opening up full probate. So what this does is it replaces what we usually call a small estate affidavit, which really doesn't tell the folks that you're using that document for what it does. And so it's now going to be called a small estate affidavit with a limited letter of authority. That's somewhat similar to what you receive in big probate when you have to open up full probate. So you can, so the folks that you bring this information to can understand you have complete authority to act on behalf of a small estate in this regard. So with that, Mr. Chairman, I'll be glad to take any questions.
Members, you heard explanation. Chairman Curcio.
Thank you, Mr. Chairman. And I just want to thank you for bringing this legislation, especially on behalf of Judge Carter. I actually had an attorney in my district approach me about this very issue about a year ago, and in the midst of COVID and everything else, I kind of got delayed in drafting it, and then I understood that you were bringing this forward for Judge Carter. So I'm glad to see this is making its way forward. Thank you for bringing the bill.
Thank you, Mr. Chairman.
Any further questions? Seeing none, we're going to be voting on House Bill 1362 to go to calendar and rules. All those in favor say aye.
Aye.
Those opposed, ayes have it.
Thank you, Mr. Chairman. Committee.
We're on item number 7. I'm going to roll mine to the hill and take up Representative Garrett again, if that's okay. Item number 8, House Bill 1199. Representative Garrett. Got a motion and a second. The bill's before us. You do have an amendment.
Yes, Amendment 5535. And
That is correct. Does it make the bill? Got a motion and a second. Does it make the bill, sir?
I believe it does.
All right, then I want to go ahead and put it on the bill. All those in favor of 5535 going on the bill, say aye.
Aye.
Those opposed, ayes have it. Representative Garrett, we're on the bill as amended. Would you like to explain?
Thank you, Mr. Chairman. This bill relates back to the legislation we passed. Now, not me, I wasn't here at the time, but back in 2016 regarding asbestos lawsuits. And what this does is it's sort of a cleanup bill because in any lawsuit, I get asked routinely that anyone practices law can I be sued? And usually the answer to that is well, yes, you can. You can pretty much be sued for probably anything that you want to be sued for. The real question is, can they win, or can I lose in a lawsuit? That's a whole nother discussion. So what this bill does in the asbestos world is it limits what defendants can be named without some sort of causal connection to the asbestos claim. There's not that many that are filed here. We're not a big industrial state, but a couple of years ago, or at least last year, there were 2 or 3 lawsuits that had 25-plus defendants, and probably half of those, or more than half of those, weren't even connected to the claim. In other states, there's some defendants that are 125 defendants. I've got a case right now where I've got 4 defendants, and we're trying to figure out who's representing who, what insurance is going to cover what, and so it's kind of a nightmare to figure out the causal connection of all these defendants that are named that really don't have a place in the lawsuit. So what this legislation does, it really winnows down a plaintiff's claims on what defendants can be named. They can't just throw everybody in the bucket, the kitchen sink at them. So that's what this legislation does, and with that, I'll be happy to take any questions from the committee, Mr.
Did I
Chairman.
hear you say your asbestos bill is a cleanup bill?
In a way.
Okay, all right.
That's right.
Okay.
Best as it can be. That's right.
All right, we got to stop that. Members, you heard the explanation. Any questions? Seeing none, we'll be voting on House Bill 1199 to go to calendar and rules. All those in favor say aye.
Aye.
Those opposed, ayes have it.
Thank you, Mr. Chairman.
Yes, sir.
Thank you, Mr. Chairman and committee.
Yes, sir. Item number 9, House Bill 1122 by Chairman Farmer. Got a motion and a second, and the bill's before us.
Yeah, and thank you,
Chairman Farmer.
members. This was brought to me by the General Sessions judges. They'll routinely sit in for one another, and there's a mechanism in the code to allow for them to be compensated up to $100 a day for their time. I think it's a fair and good thing to do because they spend a lot of time traveling and helping each other out. So this is what this bill does.
Members, you heard the explanation.
Well, let me rephrase that.
Okay, sure.
They help people out, not themselves. So it makes it sound like they're just helping them. But they help us, and they hear cases every day. So I should have made that clear.
I think, Representative Garrett, did you have a question? No. Oh, okay. Okay, you heard the explanation. Members, any questions? Seeing none, we'll be voting on House Bill 1122 to go to calendar and rules. All those in favor say aye. Aye. Those opposed, ayes have it. I think we rolled towns, right? Okay. Members, we're going to go back to item number 2, House Bill 1594 by Representative Towns. We have a motion and a second. Representative, you got an amendment, 5427, is that correct? 5427. Does the amendment make the bill?
It does, sir.
Okay.
Thank you, sir.
Got a motion and a second on the amendment. We're going to put this amendment on the bill. So we'll be voting on 5427 to go on the bill. All those in favor say aye. Those opposed, ayes have it. Representative Towns, we're on the bill as amended. Go ahead and explanation.
Mr. Chairman, could I have the clerk or somebody read the amendment for me, please? I accidentally left it over in the other committee room.
Sure.
Y'all have it?
Do you have it? Just to read, you had to read the amendment.
You mind?
Okay.
What if I can't read, man? You put me on the spot. You would do that. Oh, look at here. Get a picture. Get a picture. Get a picture.
There's your amendment right there.
This is
Thank you.
impressive.
I appreciate that.
Okay.
I love it. We need more of it, okay? Makes the world go round. Somebody said it was love, okay? Okay, thank you so much, sir. Okay, what it really deals with is dealing with actually veterans and helping veterans to, have some fees waived. But it says is the total fee required by subdivision X2 shall be waived if an applicant is a retired federal, state, or local law enforcement officer as defined in the code, served at least 10 years prior to the retirement and was post-certified or had equivalent training on the date of the official retires, was in good standing, which is very important, and at the time of leaving law enforcement agency, as certified by the chief law enforcement officer or the designee of the organization that employed the applicant. In essence, that's really what it does. It's giving them a break on their fees if they left in good standing as a veteran.
Chairman Curcio, make it a good question. You want to get your iPad back?
Thank you, Mr. Chairman.
Can't get it back.
To the sponsor, Is it your understanding that the purpose for this amendment, and the reason we've got this amendment is because it added the DD 214 form language so that the Department of Safety would know who had been honorably discharged and who had not been honorably discharged? Is that your understanding?
That was the core reason that the amendment came up, and the department helped to draft this as well. Because I didn't know what DD2 was. I thought it was a pesticide or something like that.
Right.
I mean, it sounds like a pesticide.
Right.
Oh, so you, okay, all right, okay. Okay. Everybody's smarter than me. I got it, okay. You know.
Thank you, Mr. Chairman. Thank you, sponsor.
I think we're on the bill.
Yeah, we are.
So anyway, question's been called on the bill. We'll be voting on House Bill 1594 as amended to go to finance. All those in favor say aye. Aye. Those opposed? Ayes have it.
True
Off the
bipartisan
finance
love is
ones,
taking the iPad with me, brother.
Yeah.
Belongs to the
Thank you, sir.
taxpayers.
Is it me now? Yeah. Yeah. All right. Members, we're down to item number 7, which is my bill. I'm going to pass the gavel and go out of session.
Yeah, and thank you, members. That brings us to item 7, House Bill 412. Looks like Representative Jernigan, you have an amendment traveling with this, coded 4868. Does that amendment make the bill?
It does.
You want to go ahead and explain to the committee what it does?
Sure, I'll be happy to. Members, this exempts retired police officers serving as a guard, patrol, or watch person if the retired officer meets the requirements to carry a firearm as an active police officer under the Law Enforcement Officers Safety Act, LEOSA. So with meeting the requirements of an active police officer annually under LEOSA has significant more regulation and safeguards than a typical retired officer seeking an exemption under the Board of Private Protection Services. And with that explanation, I'll be happy to
Very
answer
good,
any
and thank you for
questions.
the explanation of the amendment. Members who have any questions on the amendment? Chairman Curcio has a question. His finger was up there, hand, so.
Thank you, Mr. Chairman. Sorry about that. I just want to confirm with the amendment, are they still waiving the fingerprint requirement?
No.
Mr. Chairman, you're recognized.
No, I'm sorry. What it gives an option because when I say that it's more stringent to do it, if you're under LEOSA, she got you?
Yes, sir. Thank you very much.
Okay, thank you.
Very good. Members, any other questions or comments before we vote on the amendment? All right, looks like we're ready to vote. All those in favor of adopting House Amendment 4868 to House Bill 412, say aye. Aye. Opposed, say no. Ayes have it. Back on the bill as amended. It's been explained by the sponsor, and thank you for that. Members, any questions or comments on the bill before we vote? Seeing none, looks like we're ready to vote to send House Bill 412 as amended to calendar and rules. All those in favor, say aye. Aye. Opposed, no. Ayes have it. Bill moves on, and I'll let Chairman take us out. Thank you.
Thank you. Okay, that completes our calendars. If the members don't have any other announcements they'd like to make, then I'll entertain a motion to adjourn. We are adjourned.